questions.
Okay. My name is Dr. Matthew Rimmer. I'm appearing in a personal capacity.
Thank you.
For an opening statement, a decade ago I appeared before the Australian Parliament considering the Australia-United States Free Trade Agreement, and at that particular time Prime Minister John Howard was adamantly opposed to the inclusion of an investor-state dispute settlement regime in that agreement between Australia and the United States. The Department of Foreign Affairs and Trade boasted at the time that such a clause was unnecessary. They said the agreement preserves Australia's foreign investment policy and maintains our ability to screen all investment of major significance. The Department of Foreign Affairs and Trade emphasised, reflecting the fact that both countries have robust, developed legal systems for resolving disputes between foreign investors and government. The agreement does not include any provisions for investor-state dispute settlement. I think that's a really kind of useful context in which to consider today's bill on whether or not investor-state dispute settlement clauses should be banned in Australia. I think a very kind of important initial point to make is to kind of think about the question of the relationship between domestic courts and investor tribunals. I think a really important theme in Australia and in Canada and the United States and the European Union has been the way in which corporations have tried to deploy investor clauses to challenge decisions of superior courts. Retired Justice Elizabeth Evatt and leading jurists kind of had a really interesting statement a couple of years ago on investor-state dispute settlement. And she emphasised that investment arbitration as currently constituted is not a fair, independent and balanced method for the resolution of disputes between sovereign nations and private investors. And that's a really critical issue if you kind of think about the battle over plain packaging of tobacco products in Australia, where you had the High Court of Australia very decisively 6-1 ruling in favour of the Commonwealth Government against the big tobacco companies, and then Philip Morris trying to attack plain packaging through an investment clause. Very similar issues have been happening in Canada. So the Supreme Court of Canada refused special leave for Eli Lilly to appeal against the rejection of some of its patent applications. And Eli Lilly have tried to bring an action under an investor-state dispute settlement clause under the North American Free Trade Agreement against the Government of Canada. So I think that's a really important theme to think about. The other important thing to kind of think about is the impact of investor-state dispute settlement upon the role of government. So there's been a lot of concern about the chilling impact of investor-state dispute settlement upon public regulation and government activity. And it's been kind of particularly prominent with the kind of rise of disputes in relation to investor-state dispute settlement.
Dr. Rimmer, sorry to interrupt you there. Could I just get you to clarify the word chilling? Did you mean that figuratively, or did you mean that in a technical sense?
Well, there's been a lot of debate, particularly in relation to the impact of the North American Free Trade Agreement in terms of the way in which the threat of investment actions have been used against government proposals across a wide range of different subjects. So in my submission, I kind of cite a little piece which kind of explains how the Canadian Parliament is deluged with threats about in relation to a range of different regulatory measures that have been proposed and discussed, that if you introduce that measure, we will bring an action against you under an investment.
So you're referring to regulatory chilling specifically there in that comment?
Yeah.
Okay, thank you.
So I mean, there's been a great deal of concern about that kind of particular issue. The United Nations Conference on Trade and Development, UNCTAD, has highlighted the rise in investor-state dispute settlement cases and some of the significant issues relating to public regulation and government liability. So it's well worth having a look at that kind of particular study. This morning I was also having a look at a study that looked at some of the awards that have been made in relation to investor-state dispute settlement. I guess that is a particularly pertinent issue in terms of thinking about some of the costs associated with entering into agreements with investor-state dispute settlement clauses. I think it's magical thinking to believe that the action by Philip Morris against Australia is a one-off action. And I think Big Tobacco have been very keen on challenging tobacco control measures throughout the world and have indicated that they are very keen to take other actions. But if you look at the kind of statistics from the UNCTAD report, you really see a sharp rise in terms of the amount of actions that are being brought against a wide range of different countries, both developed countries and developing countries. So the UNCTAD kind of report emphasises that by the end of 2013, 98 states have been respondents in a total of 568 known treaty-based cases. The overall number of concluded cases reached 274. Of these, approximately 43% were decided in favour of the state and 31% in favour of the investor. Approximately 26% of the cases were settled. The global law firms who are very kind of keen on investor actions have shown a great deal of creativity in terms of the sorts of actions that they have brought. So the UNCTAD report emphasises that claimants have challenged a broad range of government measures, including changes related to investment incentive schemes, alleged breaches of contracts, alleged direct or de facto expropriation, revocation of licences or permits, regulation of energy tariffs, land zoning decisions, invalidation of patents and others. So I think it's really important to engage with some of the empirical evidence in terms of the way in which the investment regime has operated.
Thanks, Dr. Rimmer. I think it's probably a good spot to ask you to take